my name is Nertivia, NPM 1951001, Faculty of Law from UIB. In this section, I want to explain about private international law. For the first, what is the private international law? Private international law is which law applies in the event of a dispute between two or more people with different nationalities. This also called conflict of law in USA. The existence of socialization with other nations gives rise to various legal problems that show foreign elements. To solve problems caused by international relations, which show that these foreign elements, it is necessary to develop the science of law that regulate the life relation between citizen and citizen of other countries. And second, what is the aspect of private international law? For the first, the jurisdiction of forum. That means is the jurisdiction where the forum is applies. And second, the competing state laws. That means is which procedural laws are used. And third, the enforcement of foreign judgment. Private international topics include family law like marriage or divorce, children protection like adoption of children, house property, and contract between one nationality and another nationality. For example, there's a woman who is an Indonesian nationality and domicile in Indonesia, married with a man in Indonesia. The man nationality is France, but he domiciled in Indonesia since 6 years ago. After they married, their child was born. One daughter called Claudia, 7 years old, and one boy called Francis, 5 years old. 9 years old they married. Their house began to experience problems. Wife wanted to divorce, but she afraid was that the custody of the two children would fall into her husband's hand. So which forum jurisdiction there should apply and which procedure law they use. Characterization, lex patriae. The law of nationality according to the case. Lex patriae, wife is Indonesian and the husband is France. Lex domicile, the law of domicile. Their domicile in Indonesia. Lex celebrationis, the law of the land where the marriage was celebrated. In this case, their marriage in Indonesia, so lex celebration is in Indonesia. So how about lex fori? Of course, in Indonesia, because they married in Indonesia and both of them are domiciled in Indonesia, so lex cause use Indonesian law. Incidental question. Was the case brought to the French court because of lex patriae the husband? Will custody of the child fall to the father based on ius sanguinis? Will custody of the child fall to the father because the father is the participant responsible for living expense and education costs for the child? According to lex celebrationis and lex domicile in Indonesia, it's clear that the case was brought to the Indonesian court. According of Undang-Undang Nomor 12 Tahun 2006 tentang Kewarganegaraan Indonesia, a child who has not reached at the age of 18 years or is not married and already live in territory of Indonesia from a mother or father who has Indonesian citizenship, then the mother has the right to get custody rights, not only for the father. And according of Pasal 29 Ayat 3 Undang-Undang Nomor 23 Tahun 2002 tentang Perlindungan Anak explain that in the event of a divorce as referred to in paragraph 2, while the child is not yet able to make choice and the mother is an Indonesian citizen, in the best interest of the child or at the request of the mother, the government is obligated to take care of the citizenship status of the Republic of Indonesia for the child. In this case, the child is only 9 years old, named Claudia, and Frances is 5 years old, so custody of the child falls in the hands of the mother. In private international law, renvoi is sent back. That means the choice of law rules, and it may be applied whenever a foreign court is directed to consider the law of another state. Example of the case above, where is the incidental question arises whether the case can be brought to the court in France where is sui stable of lex patria husband. If the case is brought to the French court, the French court will renvoi the case to the Indonesian court, because basically the court suitable for adjudicating such cases are Indonesia court, based on lex domicile and lex celebrationis. In order to avoid renvoi and forum non-convenience, forum shopping case should be done first. Forum non-convenience occurs because the selected court is not suitable for examining case, so it must be renvoied to a more suitable court. Lex alibi-pendens is principle a court to reject a case that has already been tried in a court of another country. Why do we need the principle lex alibi-pendens? To address the problem of potentially contradictory judgment. If two courts were to hear the same dispute, it's possible that they might reach inconsistent decision. Example for this case, if the case has been brought to the Indonesian court for process, it cannot be brought to the French court because it's possible that an inconsistent decision will occur. The benefit of private international law: if an international case occurs, it will be easy to determine which forum to apply and which state's law should be applied. I think that's all. Thanks for watching, and I apologize if there is a mistake in saying because I'm still in learning process. Thank you and goodbye.